So dear audience, good day. I'm Professor Mei-Hsin Wang from National University of Science and Technology. Today, it's my great pleasure to visit Barzano, Zanardo, one of the world legendary intellectual property law firm established from 1878 from Rome. And our very kind host today is Mr. Andrea Tiburzi from Rome office, and who is the European and Italian patent attorney with profound IP experience and expertise to protect clients' innovation. We are aware that Barzano offers IP strategy, brand protection, finance and legal protection of the IP for their clients. Until today, Barzano and Zanardo have served more than 85,000 clients and handled more than 71,000 patents and over 53,000 trademarks with exquisite technique and comprehensive skill. So therefore, we very much wonder, would you mind elaborate a little bit how your firm support clients on their IP due diligence and protection?
Oh, yeah. Thank you, May. As you mentioned, our firm is very ancient. We can say that it's more than return of the century, more than 40 years ago. Mm-hmm. And of course, during this time, throughout all this time, situation and world changed a lot. But our approach hasn't changed despite the time. And our DNA is the ability, if you want, or if we try to, at least this is what our main goal is, to include, of course, the preparation of all our attorneys, patent attorneys, trademark attorneys, and lawyers in order to get the company needs of our clients. At the end of the day, what distinguishes Barzano and Zanardo from several other very good competitors and IP firm is that we strive as much as we can to, so to speak, put our feet in the shoes of the clients, of an interpreter, to understand his need and to try in some way to give him the opportunity to use the intellectual property rights, patent, trademarks, copyright, whatever it is, to reach the goals of his company, and mainly to in some way adjust the competitor relationship with their competitors. But it's clear that we don't see patent and trademarks and design and all the IP rights per se. We try to see them in a competitive context, and so that our clients, the main goal of our clients is that they have not to understand or perceive any expenses in IP rights like an outcome of money, but with an investment to protect and to manage, to protect their company and their competitive edges, but above all, to manage the relationship with their competitors. That's the main goal we try to do, and we try to foster now and possibly, hopefully, in the future as well.
Thank you very much, Andrea, for sharing the view how you your firm yourself support your client on the IP due diligence and protection. Apart from the IP due diligence and protection, the IP evaluation for the quality is also very essential. So there are so many theories or principles how people foresee or evaluate the patent value quality. But would you mind sharing the views from your firm and how you assist clients in estimating the value of the industry property assets?
Oh, sure. It's a pleasure. As you mentioned before, there is a lot of theories for making valuation of intellectual property assets. And just looking through the internet or the literature, you can find several theories or firms that provide more different approaches, Generally speaking, considering that there is a so large variety of type of valuation, we are specialized in mainly just one, or in particular one. It is the valuation of intellectual property asset portfolios, patent, trademarks, and copyrights, of course, design, and so on. in M&A transactions. So in case of mergers of companies or equity contributions or transfer, we do valuation for this kind of cases. So our audience in this respect are not just assessing a generic value or I don't know, but more our audience is a banker that has to go through our valuation, and we use theories taken from company valuation. And so we believe that a modern banker can find himself comfortable, let me say, reading through our approaches.
Yes.
So simply put it this way. So normally we are called for evaluating big or pretty large patent and trademark portfolio in case of a merge of two companies, where share has to be distributed or equity contributions and so on. And so, or joint ventures, similar stuff like this. So that's basically where we are specialized on. So we don't deal with, so to speak, the ranks of the trademarks, the most valued trademarks in the world, of this kind of ranks, where there are, scores or similar system for considering or attributing a value in this respect. So our approach can be, we don't have special recipes. Our approach are taken from finance theory. Yes. They can be found in normal finance books, of course, and of course elaborated and including in this valuation the expertise of our lawyers and patent and trademark attorneys to provide a view that not all the patent are the same patents. Not all the granted patent is a good patent.
Yes.
So there's finance and our expertise developed in more than 140 years from now.
Yeah, thank you very much for Andrea sharing the approach, because it's very important when we always talking about the value quality, but from portfolio-wise and the merger acquisition point of view to conduct the analysis, that's the main purpose. I think that would be more meaningful. So apart from the previous your important sharing, I found your firm is very good at doing damage quantifying support for crime, because nowadays the counterfeit patent infringements is always very difficult to deal with, and you have the expertise in finance. So we wonder would you mind telling us some examples, if there's any real case that could be applied, how you quantize and how you really estimate the damage to be reasonable and be more successful to be achieved?
Sure. No, in general, I can tell you some general information or experience that we have, although I cannot talk about specific cases for privacy reasons. In Barzano Zanardo, there is a long-lasting experience in dealing with litigation before national courts, especially in Italy, of course, and in Germany, as well as before the European Patent Office. And national courts, sometimes we have the opportunity to evaluate damages caused by the counterfeit, the infringement action of the other party, and there is the calculation of damages is a very complicated task. It has, because to doing that, there is no fixed recipes in some way or procedures. The most important thing is that you have to understand the exact extent of the infringement and of the damage. And above all, you have to have a great preparation, especially in usually far a discipline for a patent or trademark attorney, that is management accounting. If you want to know exactly which is the impact of an infringement for a patent, for a company who, of course, has patent or trademarks or whatever it is, you have to deal with management, accounting, calculation of the other party or this party. So it's a matter that requires a lot of business insight as well, and not only technical insight or technical knowledge in this respect. And so we, in some way, we come back to our DNA, as I mentioned before, where we try to stay close to our clients, our entrepreneur, and to understand their point of view and not our point of view of lawyer or attorneys. So that's it. Starting from this premise, normally we had some opportunity. In general, high value proceedings arrive to damage calculation in view of the large expenses required for the court experts for dealing with this matter, especially in Germany and in Italy, the jurisdiction we're more familiar with. And usually it's a tool. Often it's a tool. It's a tool for the winning party to know more about their competitor at the end of the day, and not only to get money back, because usually whenever there is large damages, it's big companies that have the opportunity to get this money. So as I mentioned before, damages, of course, are required to offset, to compensate the management. Much more often than not, they are used to shed a light over the competitor. It's more important, this aspect, from time to time. So it's used often to better understand the competitor, to know exactly where this market and so on. And this is the reason for which usually who lose a case, for example, always try to find an out-of-course agreement and not to be forced to open the books and show to the counterparty information, reserved information. So, as I mentioned before, everything in this matter deals with competition, and everything, any procedure which is, of course, created by the law, and for the necessity of the law, are usually considered and used to adjust, to manage the competition between parties. So looking at an IP law from this point of view I think it's enlightening, right? And to a certain extent, I believe.
Yeah, thank you very much for bringing a very different approach, because previously in the university, we teach students that it's a compensation for the loss,
sure,
or estimate what is the earning the winning party should have gained.
Sure.
But you bring a very important point. It's the competition.
Sure.
It's to shatter the competitors, how to preserve the data not to be open. Apart from
pay attention, switch on,
okay.
Then we take us simply. I don't know where this okay, there it is. No, you can go on.
Okay, so we can continue.
Yeah, of course. And then you can cut, of course, for sure.
Okay. So thank you for sharing the very important view of how the damage quantifying should be paid attention to. And apart from the previous sharing, we also found a very interesting service which Barzano, Zanardo show on the website regarding the patent box, because the tax issue is important for the corporate, and which indicates that business income generated from its intangible asset should benefit from the advantage of tax rate established by your patent box regime. So it's very meaningful. Would you mind elaborate a little bit for audience to learn from you?
Sure, it's a pleasure. Thank you, Mei. The situation is, we can say this, Barzano is another deals with IP, intellectual property, 100%. So we don't have any other specific activity. And the last 30 years, we tried to realize or build up all the practices for assisting our clients in, let me say, 360 degrees, including the tax optimization side. So intellectual property has become something very important in terms of tax optimization. but not only in patent box. Patent box is just one of the several, laws, tax laws that usually have a specific duration. So for 1 year, for 2 years, you have some, reduction of taxes. If you have patent portfolio or trademark portfolio or IP portfolio in general, and we give our assistance to our clients to obtain the best of the tax optimization from this kind of laws and total security. Now, but the point is that there are several other areas that don't have a duration, likewise, for example, the transfer pricing. And so for multinational that have some holdings elsewhere, not in Italy, not in Germany, but maybe in other places like the United States or elsewhere, so they can we try to give an assistance to our clients for them to optimize in order not to breach any law, local law or tax law, to optimize the use of their patent and trademark IP portfolio in general, and manage the flow, the cash flows associated to them throughout the world. So yes, it's a very specialistic discipline. Unfortunately, it requires specialized people and an update, not only national, for example, for patent law, patent box law, style law, and similar, but also international when we talk about transfer pricing agreements, transfer pricing law, and similar stuff like this. So yes, although our core business, and as mentioned before, we mentioned DNA. Our DNA is, at the end of the day, providing assistance to our clients in protecting their invention, their technology, their patent, trademarks, design, their invention, their creativity, and the investments at the end of the day. But also, and this is, of course, our core business. But in addition to all these things, there are also the need, and several clients in the last years pushed us in this direction to help them to obtain, to weed out, we can say, the best in term of patrimonialization, tax, and finance, structure, from their IP portfolio. This is what we try to do, indeed, and it seems to be the IP rights are a small part, of a company, but indeed not. And we never get bored, because dealing with patent and trademarks, innovation and technology and advertising and tax and damages and courts and so on is very hard.
Yes.
But I can say that it's a lot of fun as well.
Thank you very much, Andrea, for very comprehensive information sharing. Too. But there's another there's another matter we're very much interested for you to share, because you have very unique background. You start from the EE background, and you also have accounting expertise. Sure. And then you have managed to certify by the Italian patent attorney and also European patent attorney. That's quite an achievement. I wonder, would you mind sharing how you turn your interest into IP and explore all these successful career foundation, and then enter in this legendary law firm to enlighten all the students, the people who are interested in this career, and they could start with learn from you?
Well, I can tell you that I'm an engineer. My background is an electronic engineer. Basically, I started being an engineer, and of course, as any engineer, I get out of university, I thought myself to design something or project and so on. I came in this firm. It was quite unusual, because this is a typical B2B industry, and it's not usual to know when you're in a university to know more about this business. I get in. At the beginning, it was quite normal for me, because I had to study law.
Yes.
And of course, for an engineer, that the day before he was doing integrals, derivative, and programming, and so on. But it's fine. But for who is interested in technology like me, but also who likes to, studying other disciplines. So for whoever is very curious in general, this is the best place to be. And any student who has a good technical background, who is interested in understanding things and also to applying his skills in area that are not strictly technical but also technical,
yes.
Not strictly technical, yes. This is a great place. And I can share with you a very unusual thing. I love, for example, reading decisions. The technical board or the Board of Appeal of the European Patent Office are my favorite, because behind this decision there is a lot of thinking,
yes.
A lot of interesting reasoning that connect law, rights, and technology. It's very fun. So whoever is interested in technology as well as is curious, that's a good career, I believe.
Yeah. Thank you very much for Andrea, your very insightful sharing now about these innovations and for corporates and how you help your corporate client profit from the IP. But we hope in the near future we will soon meet again and discuss more and more intriguing issues on IP. Thank you very much. Thank you.
Thank you too. Thank you very much for